Hi, good evening. It is Tuesday, September 28th, 2021, 6:02 p.m. I'm calling the Policy Committee meeting to order. I'll do quick introductions so that we don't have to bounce around the room. I'm Roberto Rodriguez. I chair the Policy Committee. Board member Jeff Irish is present today. Assistant Superintendent Aaron Townsend is here today. Assistant Principal from Deering High School, Dr. Jake Giesman is here today, and District Superintendent Javier Botana is here with us today. Board member Aura Russell-Better, who's a member of the committee, should be with us shortly. And when she comes in, we'll pause just to welcome her. First thing on the agenda is to approve our minutes. I'll wait for Aura to be here just so that we can do it with the full slate of us. And then we're gonna discuss where we left off with the law enforcement policy review that we did last month, and we'll hopefully be in a position to advance that policy to the full board. And then after that, we'll look at the rest of the policies that we had queued up, including our drug and alcohol policy. And then we'll figure out through a discussion what the policy's recommendation will be to take that on. All right, and let's Aura's logging in, so let me wait for her to actually be live and cue it back up. Hello, Aura. I had just done the introductions and was about to postpone doing the minutes, but since you're here, we're going to take a look at the minutes from August 24th. Is there a motion to approve them? Okay, moved by Mr. Irish, second by Ms. Russell-Better. Any questions on the minutes? No questions. We do have two people on the list of attendees, so I'll ask if there's any public comment on the minutes of the meeting of last month of August 24th. Okay. And I don't see any hands raised. Any board discussion or any committee discussion? See none. All those in favor of approving the minutes, we indicate with our hands.
Is it fine too if I wasn't there?
You'd want to abstain if you weren't here.
Yeah, I'll abstain. Okay, thanks.
Yep. So then we'll be 2 in favor and Ms. Russell-Better abstaining for not being for being absent. Excellent. And so now we'll move to the next agenda item. So Aura, I said we're gonna look at KLG, the policy of law enforcement relations, and then hopefully be in a position to recommend moving it to the board. The rest of the policies we'll have a discussion and then figure out what the committee's recommendation is going to be. And how we address them. So having said that, I'll hand it off to Aaron Townsend, our Assistant Superintendent Aaron Townsend, to update us on where we are with KLGB. Thank you.
Great. So yeah, we have obviously been at work at this for a number of months now. So hopefully kind of coming to fruition in terms of this draft. Just a few updates of what you see in terms of some of the changes since our last meeting. So one, obviously, we were pending the Drummond review around some of both the language and the nomenclature, given some of the conversations we had last time, and even the naming and whether it was a Book K policy, Book J, anyway. So they came back with a recommendation of it remaining in Book K, but updating the title to be Law Enforcement Involvement in Student Matters, to be more specific. When we get to the visitor policy, they had, there's some recommended language in there to address kind of disruptive visitors, right, to kind of account for that. So that was their recommendation around that. And you'll see, and I think it'll be a matter for discussion, just in terms of the language around the request for law enforcement, they had consolidated it to two kind of, two levels, I guess you would say. I think as we reviewed that and based on what, I have understood from the committee's discussion coming into this, that the 3 levels of kind of clarity, had been the feedback that the committee had been giving all along that felt helpful and useful to delineate kind of these 3 categories. So we kind of maintained that structure in there. And then, that one gray area where it was like all the different enumerated potential violations, has been kind of trued up in terms of Maine statute and language, which is now in A2 and is kind of listed there. I think the other thing I would say is, we have been continuing various kinds of engagement in terms of sharing this with various stakeholders. So the superintendent and I have met both with, the chief and the deputy chief, now incoming, interim chief around the policy, as well engaged with the assistant district attorney for feedback around that. So I've incorporated some of their feedback. They specifically had questions that I'll name around section BC, the pieces around visits by law enforcement agencies, around having school staff present, in the case of parental, parents not being present. So they raised questions about whether that implied issues around this notion of compulsion and whether, students would feel like they weren't free to leave unless they were being detained. We think our overriding interest is that, students have, that we act in kind of loco parentis and students have the support of a school staff person present in those situations. So to kind of account for that, we added that language of informing the student of their right to leave the interview or not answer questions to just try and resolve some of that concern that they'd raised. But otherwise, I think our changes, are reflective of some of their comments and feedback. We also met with John Coyne and others from the JCCO in terms of, how this applies to protocols there. And so that was a good discussion. They're doing some follow-up work with their officers to, have some guidance for us to implement. So it was no recommended changes to the policy, but just guidance for us on the ground around the nature of that collaboration. So those were all productive. We've shared it with the ACLU team as well. They as well were supportive and similarly kind of zeroed in on that language BC in terms of visits, a place we haven't really spent much time because we had just rolled over existing language. But I think the updates as well, they had the same concern about students understanding their rights about whether they're required to be there or not, right, and are free to leave, if then. So this language is to try and satisfy the variety of concerns that showed up there. So all of that, and obviously, as folks may have seen, shared out with the larger, group that we engaged with, late winter, so that people are aware of the status of this work. So otherwise, that's kind of where we stand in terms of the updates to this policy.
Do you want to address the notifying people?
Yeah. Thank you. Yeah. There are actually two issues. Drummond came back later after I'd published this and sent it to you with one other piece and then one other piece of feedback. So I think there are two in addition to what's here, we would recommend two proposed additions, one more substantive than the other. So one is that, adding language that none of this would preclude an individual's right to pursue law enforcement action, right, as an individual outside of the scope of the schools. That had come up as a question in the feedback. Would that mean that, if someone as an individual wanted to press charges, does this preclude that or not? And obviously an individual is free to pursue that action right outside of the scope of the school. So clarifying that, adding language to clarify that, that's the more substantive one. The non-substantive one that Drummond came back with is just a little bit of language at the beginning of section B2, where it says, law enforcement may interview a student on school grounds during school hours without prior permission by school officials. And it just felt like a non sequitur of keeping the prior permission by school officials, because school officials are going to be there interacting and kind of address, they have a role throughout. So really that focuses around without prior permission by the parents and focusing the language on that. So they had just a little bit of feedback around that language that's not represented here. So those are two quick additions that came one, I, failed to incorporate the, kind of the first item there. And then Drummond just came back at the end of last week with that other piece.
Is that incorporated in here now?
No, not yet. I didn't want to, just with all these versions, I didn't want to confuse matters. So I would say, we can discuss that here in a moment. If conceptually that language is fine, certainly it's been our practice to make a few other additional adjustments before it went to the full board. So,
can you just explain that piece again? Because when I read B1 and B2, they almost say the opposite. One says that we need written consent, and then 2 says that without prior. So I'm so sorry if you.
No, that's okay. So this is focused on the language of B2. So it says, where it says law enforcement personnel may interview a student on school grounds without prior permission by school officials or the presence of the legal guardian, only when, right, and enumerates the conditions under which that can happen, right, given the role of school officials in verifying, the evidence that they have grounds to be there, that an effort has been made to contact the parent, and their role in being present. The Drummond feedback was it didn't make sense to also then say without prior permission by school officials at the beginning of that statement. So again, it didn't feel like a substantive change to the, it's really the criteria around which they can do it. The little A, B, and C that are the essential elements of that, when they're not able to have prior, permission from the legal guardian. Does that help?
Yes, that does help. Does anyone have any other questions? Jeff, go ahead.
Just one question, and it may be minimal under the circumstances. I'm generally supportive of the changes. When we look at B2, law enforcement personnel may is, when we use the term may, it's relatively passive. But then when we go down to 4, under the second sentence, the superintendent/administration retain the authority to deny law enforcement access to students for non-school related investigation. It seems pretty definitive. Is there any conflict, or is there anything that I'm missing there that should be clarified, or?
I guess I'll say it hasn't come up from feedback kind of from any party at this point in terms of it being conflicting with any other language, both from, the Drummond reviews or any feedback from any of the community partners we've named. I think, I guess in my mind, particularly that last sentence of B4, just holds out the authority, to be able to, deny that access. It doesn't, and
I'm sorry to interrupt, and I can't envision many situations where, I shouldn't say any, but many where this would be applicable. And I'm sorry, Jake, if you want to go ahead before I
was just going to suggest that retain the authority could be replaced with may, and then it's just parallel language. I don't know if that assuages your concern.
It's not a huge concern. I just didn't know whether or not number 4 would kind of negate number 2 in the sense that it, so it's just discussion. That's all.
I hadn't really keyed in on it, but I do think that it is it's somewhat repetitive of what is above. So I think that entire section would be fine to just leave at the board strongly discourages, that portion and forget the second sentence, because the second sentence is, it's already, the parameters for that are already covered in number 2.
Or do you have any questions? Aaron, I'm trying to find like the previous version of this when it was just KLG. I know that we have, the marked up version here, with the red ink. But I want to see one of the previous iterations that we had. I just can't by memory draw the question that I'm trying to aim at here. But I feel like there was another part of the one. Maybe it was a different iteration of this policy, but there was something. I don't know.
That's the link to so I just put in the link to the August meeting that, has that prior draft in there. It's a Word document, so it's.
Oh God, my computer does this thing where it opens it up in notes, like a notepad.
And welcome, Dr. Ahmed.
I'm just opening up that last thing, by the way.
Thank you, Mr. Townsend.
But this is the original Drummond Woodson model policy. No, that's not what I was thinking.
No, this isn't the model policy. The one that I'm looking at is the
one that was on the link, the one that was linked on the chat right now.
So there, under the business items 2A, the first attachment should be the draft, the draft that we looked at that meeting. The one that says draft 8/23/21. Yeah.
I'm waiting for it to open.
Yeah.
Yeah, this is what I was. Yeah, there's a lot in here that was omitted that doesn't show on the draft that we're looking at this week.
That's right.
Yeah.
We eliminated a whole bunch of specifics around what student conduct would be subject to law enforcement, the ordering of what are serious and serious offenses, and then the totality of the circumstances section that was removed.
So yeah, so there were, there's a lot here that was removed from what we had. Yeah, I'm gonna need just a few more minutes because there's a lot more changes here than what we've highlighted so far. So I just need a minute to go back.
Mm-hmm.
There were a lot of changes. Was that as a result of shoring up policy based on, because this was a shell of a Washington ACLU kind of recommendation? Were the changes as a result to conform with Maine statute and compliance with our other policies?
That was one of the bases of the changes. Yep, certainly in terms of the enumerated list of potential, kind of student infractions or issues. So that was one of them. It was, and again, the policy is kind of a mishmash, which I think gets the other reason. So it was the Drummond sample plus the state of Washington ACLU one. So I think one of it was, as kind of, I think, as I understood coming out of our last conversation, to true that up, to make it conform, to get rid of the theft of 750, the one everybody was like, why is that there, right? So that's why you see kind of the list in this current version. I think the other was in terms of clarity. I think where I remember part of our discussion at the last meeting was that clarity for staff of kind of the three levels of how to understand when and where they would be able to, or not engage law enforcement. So that, immediate health and safety, trying to state that explicitly. The second category, that's really just in consultation with the superintendent as the driving piece. And so that's where I think in trying to achieve clarity there, the recommendation, from Drummond, because if you remember, Drummond was one pushing us to think about, adopting a procedure related to this, where some of that kind of detail and the committee's interest was in trying to keep it maintained within within this one policy. So it was trying to strike the balance there. And then the third element of routine behavior issues should not be, engaged. So I think it was both to conform to kind of statute and for purposes of clarity.
Yeah. No, I'll offer my opinion. I think it's well written as it stands, and I think it kind of embodies what the larger conversation that we've had throughout the course of putting this together. So,
and Ora, I see your question. We have not entertained really the adoption of the KLGR, the procedure. We looked at the sample of that prior to the summer, I think, and determined that we didn't feel like it offered anything more than where we were at that time with just the policy itself. So.
Okay, so sorry, what is it, Chair, that you're looking at for the previous policy?
It's policy KLG. If you look at board docs, it's one of the first ones. It just says KLG, Relations with Law Enforcement Authorities draft. 8/23/21.
Okay.
It's the top document on board docs for the 8/24 meeting.
Thank you. I was looking at the R1 thing.
Well, I'm to be honest with you, I'm a little bit I'm not entirely sure that I feel comfortable given. I mean, there's just a lot of stuff that was omitted from what we saw last month, and without an explanation of why those things were removed, like the particular board is now part 2, but it used to be section B. That list is just, I mean, we went over that list and we had a pretty thorough discussion as a committee about it, and we've narrowed it down to 1, 2, 3, 4, 5, 6 to 7 things when we were, almost nearly twice as many. But, part of what we liked about this policy is that we were hitting those items specifically, the clarity that we have behind it. So to just see that list cut, in half, and then I think we're moving away from what I felt was really helpful from that policy, and I think we left with one recommendation or one big question mark, which was that language on that second paragraph that we said was redundant. Other than that, I didn't anticipate such a big chunk of the proposed policy to be edited. Yeah.
But I think, can I just try to answer Mr. Rodriguez's? I think the way that it was worded before, it were the things that people were not to call the police for, and now it's the things that they're supposed to call the police for.
I know, and that's what I mean. Like that was what was good about that's what we felt was helpful about the other policy, that it really eliminated all these areas where we shouldn't call them. And then this policy now is going the complete opposite way.
But it's anything that isn't on this list, you shouldn't contact the police for. So it's all of those other things plus anything else that somebody.
And I was going to state that is that when you define it I think the last version of the policy went A through O, which necessarily restricts as a policy educators or staff from just addressing A through O, but any other variable is not taken into account and becomes a question. If we define what is necessary to call, then anything below that is subject to the written policy.
Well, we had a disc. I keep referring. Okay, so we've had we've. Jake, go ahead if you have something to say. I'm gonna think mine too.
Yeah, I actually like the economy of the way the current draft is written, but Chair Rodriguez, I wonder if what you're looking for could be satisfied by having a list of examples under A3 of some examples of things that would not rise to the level of consultation.
And I
guess what I'm aiming at is that, you know, we've the reason that we wanted to be really specific with the policy was literally so that we didn't leave it up to someone's subjectivity. And those items that we listed there on last month, you know, like altercations, harassment over the internet, like all, you know, there was a reason why we listed them. You know, to not have those specific things there, my worry is that it is going to be opened up. To not have it listed and to the only reasons that it could be called, it doesn't encompass the entirety of when we normally would call them, and now we don't want you to call them. So I just worry that this version of it does the opposite of what we're trying to do, which is tell people when not to call the police.
I'll jump in really quickly.
I don't think we could put together. I think it's disingenuous to put together examples of when to or when not to. You would run this policy would be 87 pages long if we had to outline any kind of infraction that should be called. And I know we had some level of agreement in the last meeting, but I think this course of action takes a more definitive approach and leaves administrators to use their judgment based on particular infractions. So, Jake, go ahead. I'm sorry.
No need to apologize. I'll disagree a little bit with Superintendent Botana. The way that A2 is phrased, it posits lists the items A through G as a list of examples. It says it's not necessarily limited to. So again, I'll just propose that structure, that there could be a similarly non-exhaustive list of examples after A3.
And we're still under the premise that this is an overarch, as Assistant Superintendent Townsend proffered, that this is an overarching policy that will be followed up in concert with law enforcement to make a policy or a procedure rather than a policy on how staff move forward with this.
Well, I mean, just to that, I think, you know, what I've certainly, and I mean, there's a bit of tension in, you know, in part, I think that's reflected here from the Drummond perspective of what's appropriate in policy and what's appropriate in procedure, right? The Drummond perspective would say policy is not where, you know, the kind of the enumerated lists of examples and so forth go, and it's broader, you know, speaks to the broader kind of conceptual pieces, thus the, like, you know, 1, 2, 3 under requests for law enforcement, and that, you know, their recommendation was the adoption of a procedure. My understanding of our last conversation and in all of our conversations, even going back to, you know, Ms. Russell Better's comment was, you know, we didn't, you know, had valued having it just here in the policy versus having an adopted related procedure around it. So, so we've, I think, had that conversation twice and said, you know, we wanted to kind of stick with the policy. But I think part of this, you know, rests a little bit in just that, I don't know what the right word is, but just, you know, the issue around what's appropriate for policy versus procedure issue. So, which...
Mr. Rodriguez, would it help to do what Jake suggested and move some of those or all of those under the under number 3?
Yes, it would help. I'm still trying to figure out why they're not there right now. I'm trying to figure out.
That's why I'm asking if we put them back in, would you be satisfied?
I mean, I think the reason they're not there was, I'll say, like, that has been from feedback from everybody, from high school admins to the police to the ACLU. Like, that was the most confusing part of the procedure, or the policy. Sorry, I'm getting myself confused. That's the place where we've gotten the most feedback about why this, why not that, what about this, what about that. I think that, so thus, I think it's been named, it was trying to be, kind of flip it and say, to reduce that confusion in service of the goals, right? Because I think, I don't hear I don't hear us having a question about, but let me ask it as a question, Chair Rodriguez, right? The notion of like naming the 1, 2, and 3, I feel like that has been consistent where we've been named like, immediate health and safety, right? Should be authorized to, we use that language. There's a set of things that only where it's not immediate health and safety, serious law enforcement in consultation with the superintendent. So this is something happens, there's not immediate health and safety, but the expectation is that then they consult the superintendent's office. And then essentially everything else doesn't. So it was in service of trying to like get to clarity of those 3 points, was the purpose of it. But I'm hearing your feedback.
Laura?
Sure. Mr. Townsend, I just wanted to clarify when you just explained the feedback from, sounds like PPD, ACLU and others, that the reducing the confusion. So was your understanding and their opinion that having the list of what does not constitute contacting the police versus instances not to in detail was what was feeling confusing?
I guess I would just say, that, most all of those conversations began with questions about, well, why is this there? Well, what about that? Why the 750, about the specifics of it? Okay. How did you get to that? Those kinds of things. So and I've shared with them this updated draft, the one that we're looking at tonight. But just because that, got finalized or, got to this stage last week, we haven't had additional follow-up conversations related to it since then, okay, in terms of this version.
And so part of what I recall us talking about when we discussed the other overlap or the other intersecting policies that touch on this is literally the reason why the proposed current version doesn't make sense. We have a bomb threat policy. We're about to go through a weapons policy review. We have a drug and alcohol policy we're going to review. And so we said as a committee that we tackle each of those policies individually that involve the use of law enforcement. But this particular policy was going to do the opposite, what it was doing last month, which is dictate when we don't call law enforcement.
I would say let's follow Jake's suggestion. Let's put them back in there, but do it with language that makes it that it's not exclusive, that these are not the exclusive ones, just as for consideration, just in the same way that we do around those other, the reasons why you should call the police. I think that we've explained the reason, why it was removed, and that's not satisfactory to at least one of the board members on the panel. So we should just move forward, put it back in there and, then let's bring it to a vote.
Where are we going to put it? Because now
under C.
Under 3, you mean?
I'm sorry, under 3, yes. So something, like such as, or, what do we use? Including but not necessarily limited to, which is the same language that we use above for the things that you should call the police for. So just include, that same language, including but not necessarily limited to. And then that list, but, we know that some of those, are problematic. And I think that's why, this whole conversation started around theft under 750, and everybody's like, where the hell did that come from? So, that's the part where, we'll need to go back and, and clean it up and make sure that they're the right ones to have in there. But I just don't see this back and forth being super productive.
All right, go ahead.
Thank you, Chair. This may have been addressed before, so I apologize if we've discussed this, but I just go to being curious about once these substantive changes to these policies are made, I'm trying to wrap my head around how does staff learn and understand what these changes are and then to be implemented them. Because I'm hearing what the chair's saying and, the pieces that, he may have addressed. He's concerned about, it being very explicit in this policy in particular, but I'd like to understand a little bit about that, in the implementing of these. How does staff come to learn and understand them?
We share them with the principals, and then we, that becomes practice after that. And we're not always great at it.
Okay. So that's just, I guess, my mind goes to that, that next piece is another issue altogether. Mm-hmm. But I do think the understanding of it is a piece that I can see the explicit, us wanting to be very explicit in that. So
I've been sharing the iterations of these drafts with high school administrators as we've been moving forward. Our practice has been when policies are going to the board, we share them with all, school leaders and district leaders. So all the ones that we did like the first read of last time, the elementary. So they did that. And then once they get adopted, we have a structure around business meeting where we'll review them and the implications around that and so forth. So.
Okay, thanks.
Yeah, I think I do want us to put the list back in. I think that literally what the superintendent said a moment ago, that we're not very good at it, is why. I think that having specific policies is helpful. I'm not going to suggest that paragraph 2 be removed, but that paragraph wasn't. I'm sorry, not removed. I'm sorry. Paragraph 3. That the entire list be condensed. I think that the entire list, we should be from last month just brought over here. I don't understand.
Well, but many of those things that was what we had said was the review that we needed to go through to that, to conform with kind of the Maine statute and policy, which things were appropriate or not. That's the list that came from the Washington policy.
Yeah, but like you said, so were there any specific ones? Like we talked about the $750, were there any specific ones, or we just eliminated the whole list just because? Yeah, I don't understand. There were 14 items there. I don't understand why.
As well, the cyber, truancy, Maine state law requires, notification around truancy. In terms of harassment, the abuse and harassment, there's, statute that exists in ours as well around, potential referral for law enforcement, kind of criminal, if it gets to that level. So yes, there was more than just the randomness of the theft of 750. But again, I think it was some of that, but it was also, again, to the point of just, trying to have, and there's different perspectives about what administrators need to execute on the policy, that those lists buried the essential guiding principle that we need people to be clear about, which is health, immediate health and safety. You're authorized to. Any kind of major crimes, you call the superintendent's office before calling the police if it's not an immediate. That's what needs to happen. That's the thing we want ultimately to train people on, right? Well, we're not going to get them to memorize a list, and then otherwise don't. You got to deal with our school policies, the threat assessment, right, as it says in our behavioral intervention plans. Otherwise, you just don't, right? And we need to manage it. It's our job and responsibility. So, it was this, that's where I think the spirit was trying to get to the same thing. Sorry, the lighting is weird here. I keep going in and out. So anyway.
But some deliberate version of A through O could go back in.
Sure. Yep.
Yeah.
Okay. Okay. Any other?
What are we? Excuse me. What are we discussing here exactly? I mean, not what are we discussing, but are we pushing this off again for another policy meeting to identify what should or shouldn't be in examples? I'll say I'm supportive as it's drafted, minus the second sentence in section 4, but should that consideration, should it be adopted similar to what we did last week, I think, or last month? Should we adopt the version as is now and send it to the full board to discuss whether or not particulars need to be in? I'm kind of at a, all right, are we going to just insert those and then vote, or insert the A through O and just, but then we have to go back to, I assume council stripped those from the policy based on what Aaron just said is lack of statutory ground, or it's covered by other policies. And I'll leave it to the chair. How do you want to, do you just want to insert it and vote, or does it need to be vetted again based on the adjusted language that's in there now?
Yeah, I guess the best way that I can sum up what my concern is, we have a list of reasons why when we would call the cops, and almost all of those reasons have a corresponding policy. Now which in the last version we didn't have that list precisely because we have corresponding policies for those situations that tell us when to engage law enforcement. So to substitute what was the intent of this policy last month, which is to dictate when we don't call law enforcement with an extensive list, then it's sort of kind of, to me, it's starting to miss the point. I don't want us to go deeper into this. I think I'm starting to understand that we're just not really moving forward. Yes, I would like to see the list A through O back under 3. That's what what I'm suggesting we do right now.
Can I also point out that we did have those circumstances under which you would call the police? They were listed there. They were under letter D.
I know, and our discussion said that we maybe not have them because we have corresponding policy for those things. So we left it saying that those shouldn't be there, and then we came back with only that there, and then the other stuff that we all agreed was like the best part of the policy is not there. That's where I'm at. Like, this is opposite of what our discussion was last month.
And I'll leave, this will be my last comment on it, I promise, is that I think Assistant Superintendent Townsend has had a collaborative effort with not just policymakers on this committee, and that he's engaged stakeholders to include staff. Well, I won't go through the list because I'd probably be doing it an injustice, but it is helpful that we've collected that and we've adjusted the draft accordingly. So it's important to engage those rather than just say, I want these A through O 15 line items. I actually think I'll leave it at that. But so I know we have some disagreement, but we'll move forward.
Can I just clarify, Chair, if this is voted, this was to go to our next board meeting for approval, is that right?
We were hoping to approve it today and send it to the full board. so it could be on the board's agenda.
Okay, thanks.
So let's do this. Let's vote on the version that's in front of us right now, and have the discussion with the full board. And then in the meantime, you just have the full discussion on the board.
I would prefer not to bring something that, that you as the chair of the committee are not supportive of. Honestly, I think that, it doesn't make sense to bring something that you're not supportive of.
Well, I appreciate that. I'm also not going to hold up the work of the board just because of, as 1/9 of the equation. I mean, I don't want to be critical of the process, but I mean, we saw a very similar version of a policy several times, and the time that we go to vote for it, it's substantially different. So I appreciate that we just recently got feedback from some folks, but it's not like we hadn't gotten feedback on this policy from other folks too. So we are in essence just following the recommendations of the most recent group of people that we gathered, not the entirety of the group of people that we gathered input from, because that's what we were looking at last month, was reflective of people that had already taken a look at it. And I'm going to just repeat myself here, and that's not going to get us anywhere. So, yeah.
Can I just ask, Chair, and I'm sorry if this is repeating what Mr. Irish said, but if the A to O is put back in, does that to you feel like something that you're comfortable moving forward?
Yes.
Okay. I'm happy to vote on that to move it forward to.
I'm going to retract my promise from my last statement. A to O, I assume, was removed. I mean, we would have to. We can't just insert A to O without vetting it through council again, because again, that $750 provision still lives in there, which does not conform with misdemeanor statutes in the state of Maine. I assume I'm cognizant of the fact that the people who were perhaps most recently introduced to this discussion, i.e. council, are much more well-versed and smarter than I am in these kind of things. And to think that it was removed based on a whim, I think it was removed intentionally to keep it more open. So when I'm not going to get into the whole I think this is the third time I've reiterated it, but we can't just say, let's vote to put A through O back in without us having another reiteration of this conversation.
Mr. Giesman, wasn't there like an additional piece of language that you recommended? Was that for this part? To have a little bit more flexibility about that language?
Superintendent Botana said, you can use that same language from the other list that says not necessarily limited to or whatever. Yeah. But I do think, Assistant Superintendent Townsend, you said that a couple things that are in A through O would need to be removed because they conflict with other policy or law. So it seems like we can't just wholesale put it back in. Seems like a solvable problem, but maybe not as fast as we would hope.
I mean, I guess I'd like to acknowledge that substantively, out of a brand new policy, we are, I don't hear disagreement around the notions of, conceptually, delineating when, when we should be engaging law enforcement, right? And how we should act if law enforcement shows up on our doors to the visit. So I just don't want us to lose sight of the fact that we've established a policy that here previously has not existed at all, and that what I would view as like the core elements of it I think we've gotten to clear alignment around it. Was trying, some of these changes, and I hear the feedback about, Roberto. I mean, anyway. But I just want to name that. Feels like I'm not hearing disagreement about kind of the core elements of the policy. I appreciate, Roberto, kind of the perspective that additional guidance, right, kind of within the context of the policy, you see value in that. So I hear that. We could include, as we've talked about. So I guess looking for direction around whether it is, we've articulated a couple of, additional, proposed, non-substantive change from Drummond that we talked about earlier before we got into, kind of this detail, and some of the language around, not precluding the right for individuals in their own accord to pursue law enforcement. So, there are a couple of proposed changes that are kind of on the table here potentially, but I guess getting clarity about direction of next steps with this.
Yeah. So as Jake said, if I'm still would like A through O to be considered. If there are specific ones that make us fall out of compliance with statutory requirements or other legal requirements, then take them out. But to get the whole slate, just because there might be a question mark around one or two, that's the part. So the reason I'm saying this is, again, it's how these policies are then, practiced. And I don't want to get into a discussion about other policies, but we currently have recently revised policies that we know currently, as of the last month, are not being practiced in our buildings well or as intended. So being specific about these policies, to me, now more than ever, becomes really important. And particularly in what has been the intent of our law enforcement's relations reform all along, is to be really specific, because the lack of clarity and the disconnect that people had on the understanding was causing problems. So literally what I believe was going to be the biggest value of the policy is now really just not the biggest value of the policy, because it lacks that specific clarity. Whether that, is the make it or break it or not, I'm not going to decide it. But to me, that's where I'm stuck at.
Can I just ask, Chair, procedurally, is it possible for the piece about the A to O and, the state statute piece to be problem solved outside of this, so that, it might not be before our board meeting next week, but that we don't have to wait till our next committee meeting to move forward? Or I don't know if we have to be meeting to do that, to make the next decision.
You mean, I guess what the first question was, do we have to bring it back to the policy committee one more time? Is that what you mean?
Yeah, I just didn't know if council was able to look at the pieces of A to O that would have to be out versus, and we had a draft somehow for us to see, could it then go to the board and not have to wait till our next meeting?
I think what I heard Chair Rodriguez offer was that we would go back, eliminate those that were in conflict with the statute. So that would be something that we could do by discussing it with council, and then bring that back. So, adding them in to A3 with the same language as A2, including but not necessarily limited to, with the removal of those that are in conflict with statute. Is that your understanding as well?
And then that could go to the board. Okay.
And we can do that without it coming back to policy?
As long as you vote for it with those parameters. That's what I have in the notes right now.
Right. So, Jeff, I know that you were looking at this list differently, so I want to just give you a fair chance to see if we were to bet the list A through O, to clearly identify the specific ones that we are that we would not be in accordance to laws. If we were to, would you be okay having the list?
With reservation, but in an interest to move the whole of the policy forward, I think that's probably pretty prudent. I mean, I would be interested in seeing the list, but I get your point, Chairman, and I thank you for the opportunity to comment, and I'm fine voting forward under those conditions that Superintendent laid out.
Great, appreciate that.
You would see the list when it shows up in the policy that you would.
Right, but I'm.
No, I know what you mean.
Yeah, some of it, I just think once you add it, it might add a level of confusion that might have unintended consequences. But I mean, if the majority here decides that a reduced list, a vetted list needs to be part of the policy, then I think I'd be all right with that.
And to be fair, I'll say this now, but what if, right? Like that list is condensed to like one item. So I want us to try to be as specific with this policy as possible, because the lack of clarity is what's gotten us in trouble in the past, and the lack of clarity is the reason that we went into this in the first place. And is what, again, everyone that I shared with the policy with over the last couple of months since we had that version that I'm referring to, that was the part that they all highlighted. They had questions about some of the confusing language further up, where we had a lot of the mays or could not, but then that list of when we don't call them was what everyone said. Oh, I like that you guys are being specific about that. I like that that's there, and I get it that those were not our administrators, but they were a lot of the same groups. They were folks, attorneys from the ACLU. There were former educators. There were policymakers from USM. There were people that work in public health. There were people from the Department of Health and Human Services. So I was reaching out to people that I thought were going to have the right policy lens, and they all highlighted that section as the one that they liked the most. So that's why I'm advocating for it. Having said all that, I'll move. Oh, if we can move for the committee to approve the policy KLGB, with the expectation that the list of circumstances where police officers will not be called is going to be vetted. We have a motion for that.
So moved.
All right, moved by Aura and second by Jeff. Are we clear on what we're asking staff to do? Do you have any questions around that? Okay. I'll ask us to vote if we want to send this policy up to the full board as we described. We can indicate with our hands. All right, so that's unanimous. And Javier, I guess, when you and Emily figure out your agenda setting in your agenda setting meeting, are you anticipating a workshop for this?
We'll definitely need to have a workshop, but I would like to see what we do with the other policies yet today, because I would be my preference would be to bring more than just this policy and to have the workshop be for more than a single one. But, if we don't, if we can't get through everything, then I do think that there's a question that needs to be asked about that. I am trying to think, what do we have? We have an executive session at the beginning of next week's meeting, but we don't have a workshop, so we could potentially do this as a workshop.
Right. Well, when you and Sheriff Victor do your agenda setting, I'm sure you guys can figure that piece out. I'll let you guys manage our time. Right, we can move on then to the next agenda item, policy JEA. I know I'm in the wrong meeting, sorry. That was the attendance one. We're moving now. I guess, did we want to talk about the remaining policies at all?
We got half an hour.
Yeah, go for it.
And
okay, I'm gonna go off camera real quick. I'm sorry.
I guess I'm curious. My hope in getting them out, just some of these have very minor revisions, right? Virtually none. Others, ones we've already kind of discussed. I'm wondering if we can kind of take them just policy by policy, not, so I don't know the level that folks have had a chance to review them prior to the meeting or whether folks need time in the meeting, but ideally folks have had a chance and we can just address, okay, are there any questions about the bomb threat policy or administrative guidelines? And
would it be possible for you to single out the ones that have the least number of changes so that we could try to peel those off before we get into the ones that are going to be more substantive?
Yeah. Yep. So we could start with essentially so the least changes is the security camera system policy. And the related administrative procedures. There's in the policy itself, it just updates a single cross-reference. There were just a few kind of editorial revisions to the to the administrative procedure. So very few substantive changes.
Can I just throw something out there in the interest of time?
Mm-hmm.
I know Roberto chairman had stepped away, or I don't know whether or not you've had the opportunity to review. I've looked through all of them. I don't see any substantive changes that I would disagree with. And to the extent Ms. Russell Better or Chair has concerns about any of the changes, do we need to go through them, or is it a matter of public record that we do?
We should probably take action.
No, right. I understand that, but having reviewed and looked, I don't see anything, but that's just food for thought. If you want to, I'm not saying fast forward and not address perhaps what we should put out there in public, but it is there for people to see. So I'm just throwing it out there.
I didn't have any big concerns, but I think I had a couple questions, so I'm just going to peek through and the security ones. I thought I just had a question.
Did you have any questions about the security cameras, Ms. Russell Better?
Yeah, I'm just, I don't think it was anything big. I'm just trying to remember. Okay. The operational was added. That made sense to me. I think I was just trying to understand. Maybe this was my question. So at the very beginning where it says commented in section A, the sample had another paragraph in the section allowing the short-term placement of cameras for investigation of misconduct, illegal activity. So I'm not clear. So that was in the previous, and now that's not here at all. Is that right?
That's referring to in their sample policy, which we haven't. They just reviewed our existing policy.
Okay. So there never was, and there isn't any language about short-term placement for investigation of misconduct, illegal activity. That's not part of this. Okay, thank you. That was the only part that I was unclear and didn't like that language. So, okay, thank you. So I didn't have any other concerns.
Great. So go ahead, Roberto.
Nope. I was just going to say I didn't have anything on the camera, on the security camera policy.
So maybe we can just go through, just see, kind of to, member Irish's thing, like, yeah. Okay, so security camera, maybe let's just go through with questions and then could have go through with the procedure to, so bomb threats, either the policy or the administrative guidelines. Did anybody have any questions around the bomb threat policies and the revisions there? Okay. And then, some of these we had reviewed back before we started the work on what is now KLGB. We actually walked through a deck of proposed revisions. So, for example, the remaining ones, we actually had talked about what these substantive changes would look like, back in April or May. But I think maybe the first time looking at the language. So JICH, the recommendation was, as you can see, the proposed changes there. Are there any questions about JICH or JICHR in terms of the language as it relates to law enforcement? This is the one I want to caveat that I do think we should not advance right now, and should be, over the course of this month, I'd like to consult with a few public health folks for recommendations. This came up as well when we did the tobacco and vaping policy to kind of align our approach to that. So, but from the law enforcement perspective, are there any questions?
When do we? I'm sorry. When do we proceed taking on the
I mean, I would propose bringing a draft to to the next policy. That's the focus of our next policy committee meeting. So that would put us, I think, I have a vision of who to engage with and how, right? And to kind of bring that forward for consideration so that potentially we could, move that forward in November. Or by November, sorry, so that we get it done this board calendar year. That would complete our work plan. So we can table discussion around that. Certainly we come back.
Yeah. Let's do that.
Okay. JIH and JIHR, the questioning and searches of students. Were there any questions about the proposed language in those policies? Right.
Is this one you don't foresee us having a deeper discussion on? The questioning and searches of students, and because the changes are very minor.
No, I mean, I think we had applied, the 4-quadrant kind of criteria to this proposed change. And, this was one we did have some discussion back in the spring at some point. I forget which meeting, I don't think we looked at the draft language, but the conceptual changes, from one of our spring meetings. So, yeah, I guess what I would say is, the two substantive things is the evidence forwarded at the discretion of the superintendent to align it with kind of the May, the engaging with law enforcement, right? Kind of, that seems to me that aligns to, KLGB in terms of, that it's in consultation with the superintendent, and then clarifying the firearms violations, which, we'd gotten clarity on as required by federal law.
I guess I just have a question about the strip search piece. I see that it's highlighted: if a strip search appears to be necessary, law enforcement authorities shall be contacted. So that part is, what is does that say deleted?
Yeah, let me go.
Can you clarify that? What does that mean with that line? This is in second page.
I would you know, I would suggest that we not move this forward until there can be a substantive discussion about it. I'm not comfortable with, you know,
Yeah, Ms. Russell-Better, I would agree with your question in a sense that if we find ourselves in a position, I don't think a district should be contemplating that kind of activity, even on any premise. Yeah, I would not want to be a staff member responsible for having to. So yeah, I'd be on board with tabling that one.
Yeah, let's keep that one for further discussion.
Okay. So then we had the JRA and JRAR, the student records. So the primary change there was eliminating the designation of PBD in terms of as the designated law enforcement unit, which in practice means, that they need to, go through a formal process to request and for us to share information as opposed to us being able to share information without parental consent and so forth.
Everybody's good with that one?
Mm-hmm. So then the last one is visitors to the schools, KI. So again, one of the major changes was taking out the sections from there that referred to Department of Health and Human Services and law enforcement. Right? That's what kind of led us to the establishment of KLGB. We need to have kind of as a pending to do for this committee is to update the child abuse and neglect reporting policy to incorporate that language there so that it's in that space. So that's a to-do for us. But that's, that was just kind of clean cut. And then in this most recent version, there was just a sentence added around, out of the conversation about whether KLG or KLGB as it is now, referred to staff, students, and community, or whether it was focused just on students. So we elicited a proposed sentence around, dealing with visitors and whether there's authorization there. So.
That additional sentence, the suggested sentence that unauthorized visitors and trespassers, law enforcement may be contacted as necessary when dealing with unauthorized visitors and trespassers. May be contacted to assist with authorized visitors who become disruptive during their visit to school premises. I don't have anything. I don't have anything against that recommendation. It seems, I don't have it's just not. Okay. Anyone else on that one?
Can move forward on that one, or assume that we're ready to start that?
I'd be speaking out of school here had I not. I'm just curious about when a caseworker is acting as an agent for the Department of Health and Human Services or the commissioner. Do we have the authority to block that? Are we separating the two, like law enforcement and DHHS over here? Or maybe I just missed the...
What we did is we took it out of here because we put it in KLG. I got it. So this is all, not verbatim, but this is the basic language that was there.
Yeah.
And this other language was added to address other visitors to this. You know, what could law enforcement be called if there was a disruption by adults in the building?
All right, I understand. Thank you.
Okay.
So this, sorry, I'm good moving this one forward.
Okay, so then it sounds like we'll hold back JICH, you know, and there's work, the body of work to do there, which I've had kind of on my radar for some time, is kind of engaging with our public health partners, just around updating. There's some other model policies, you know, that we looked at when we were doing the tobacco and vaping to, as well, you know, come from a more kind of substance abuse perspective as opposed to a, you know, punitive perspective. So we'll do some work to bring forward some recommendations to the board, you know, to the committee around that policy. And then JIH and JIHR, questioning and searches of students. You know, I know we can have a more substantive discussion. We could bring that back, you know, at the next committee meeting. I don't know if there's any other additional work that we should do in advance of that to prepare for that discussion. Anything that anybody want to highlight?
For which one? I'm sorry, for JIH?
Yeah, the questioning and searches. I'm fine if there's not, I'll say.
I want to email you that. I don't want to do it now on the fly. I want to sit with it and send you a couple of things that floated, just because I want to get my thoughts together.
Okay. So we'll prepare for a more kind of in-depth conversation on that one at the next meeting.
Can I just ask quickly, Mr. Townsend, have you already seen best practice language around that? I just don't know, you know, what to refer to as far as like how would one, you know, determine in policy, you know, making the decisions about searching. Is that something that?
I don't know that I would say that I've seen something as best practice. I mean, we can, you know, that's part of, so we can do a little background and see if there's anything to help inform the conversation for sure.
Okay, thanks.
Yeah, I would only offer that I hope that takes place in outside of school. I can't envision that being anything that would take place in our district, but to the extent it warrants a strip search or a search or something, that needs to be out of our control.
I mean, so I do think that that's why I think we should have a substantive conversation about it, because there are, you know, aspects of KLG that say, for example, that you should not call the police for, drugs that are in your possession for personal use. And so, you know, in some cases, the only way to find that is with a search, you know, hopefully not a strip search, but definitely with, you know, some form of searching. So that's where I think it gets a little dicey, and we probably should think through what are the, you know, best practices around that. I mean, I agree. Like,
sorry, that strip search thing may have come from a former corrections world I used to have. So when we're talking about searches, I certainly understand your aspect in that point.
Yeah, to me, the search piece, obviously, you know, that I'm glad that we highlighted that. Excuse me, in the searches, you know, one of the things that I think I want us to discuss. So, for example, the smell of marijuana could give a staff member reasonable reason to search a backpack of a student. Is that accurate to say? Yeah. Okay. So my understanding and my experience is that if I walk into most bathrooms in our high schools, I will probably encounter either the smell of marijuana or vaping, or some residual smell of it. So it becomes like literally anybody that's in the bathroom, I could reasonably ask to search their backpack. And I'm painting a picture here of a really like silly thing, but what I'm getting at is that, you know, reasonable or giving a staff member reason, subjectivity to search somebody's backpack, to me is something that we really want to be able to like understand when it happens, how it happens, before we can even talk about what we want the policy to say. Yeah, I'm sorry that I'm not doing a good job explaining myself tonight. But I would like us to discuss that with a better understanding of how these searches happen and how they have happened with examples in our high schools.
Okay. And just for clarity, I think that comment was intended as a suggestion to delete that sentence about strip searches. Is what that was. But we'll come back to that policy. So, maybe just to tee it up for you, Chair, here in terms of process next. So we have, we've already had action on KLGB, but now we have the bomb threat, security camera, student education records, and the visitors policy as part of the suite of policies that it sounds like we were ready to take action on to move to the full board.
Yeah. So I'll do it formally. All right. So I'll move that the policy committee advance policies EBCC, EBCCR, ECAD, ECADR, KI, and we already did KLG.
And then also JRA and JRA.
JRAR. Is there a motion? It's better. Second, and Mr. Irish. Any questions? We know which ones we're advancing, right? Okay. All those in favor indicate. Unanimous. And then we'll queue out those other ones for next month then, for October. For October, yep. So, all right. Do we have anything else on our bucket? We weren't even supposed to do that. All right. Outstanding. All right. So if we don't have anything else, we have 7 minutes remaining. It'll be really cool to finish something early today, or ahead of schedule. Apologies if I honestly did not feel like I was explaining myself very clearly today. Not my best word searching or word finding moment. So I apologize for that. I appreciate that some of you tolerated me. Having said all that, unless there's anything else, is there a motion to adjourn our committee meeting? Ms. Russell Vetter, second by Mr. Irish. All those in favor indicate. We voted at 7:24 p.m. to adjourn our committee meeting. Thank you, Aaron and Superintendent. Appreciate it.